Hi, everyone. Welcome to the webinar. I'm Christy Baglow, Director of Statewide Training at Florida Legal Services, and I am delighted to have with us today Juan Carlos Arias. He is an attorney at Anidjar and Levine, and I want to thank Alicia Herwood at Coast to Coast Legal Aid for connecting me with our speaker today. It looks like this is a popular topic. We have a ton of people registered. So in order to get through all the material, we will hold questions until the end, but you can type them in as you think of them in the Q&A box. You should see a red live button on your screen, and that is how you access the closed captions. And I also put the link in the chat box. This is being recorded and will be sent out tomorrow in case you would like to watch again or share with coworkers. And CLE has been approved, so I'll announce that at the end before we take questions. So thank you again, Juan Carlos, for being here today. And I did want to tell you a little bit about him before he launches into the presentation. He's very experienced in this area and focuses his work on lawyer regulation, ethics counseling, unlicensed practice of law, and representing students before the Florida Board of Bar Examiners. So we are so fortunate to have him here today. And I did want to mention for any of our Stetson Law alums, he graduated from Stetson Law School. So welcome again, and thank you for being here.
Thank you so much, Christy, for the introduction. And welcome, Florida. The numbers keep going up, Christy. We're at 105, so that's great. Great job spreading the word. It is a pleasure to be with you from my office in Fort Lauderdale to talk about the challenges and the best practices for legal aid attorneys working under the pandemic conditions, as we all are these days. Just a little aside, I serve in the board of our local legal aid for several years and have great respect for the work you all do. And I want to thank you. It is there's a lot of sacrifice that goes into serving our communities from these so important offices of legal aids across the entire state. So thank you for your service. It's one of those kind of selfless jobs out there. And I've had my share of them too. So as you already know, I do this for a living. 80% of my time it's on ethics. So it is truly a pleasure to be able to talk to all of you about the topic. Christy, can you tell me, do we have a mix of attorneys and non-attorneys and support staff, or what do we have? Who is my audience of 121, 122?
We usually do have a pretty good mix. It'll mostly be staff attorneys, but some leadership within legal aid, a few pro bono attorneys, and a few non-attorney staff.
Excellent, excellent. If you have any questions because of the amount of people that are participating today, 126 right now, save them to the end, and then you can submit them. And Chris is going to do the selection of the questions that I'm going to answer. I have all the time in the world, Chrissy, so if you want to stay longer than 1 hour, that's fine.
I really appreciate that.
Thank you. I had to go here. I had to go here because what a best example, what a better example than what just happened this week. The "I'm not a cat," the most used phrase now for the last 3 days. It happens. It happens. Virtual. It's here to stay now, and we all need to step up. I don't know if you know the history. I actually saw the attorney on TV yesterday, and he was explaining that he's a more seasoned attorney, and he asked the secretary to set up the hearing, and the secretary's daughter had used the computer. And that explains why the filter was left on and the whole thing happened. So we all need a little laugh these days, and I don't think it can get better than this, especially the eye movements of the attorney behind that mask. It was just hilarious. So let's see if we can prevent things like that from happening. And I may have a couple of tips on how to prevent that from happening. Overview of what we're going to talk about. Best practices for text communications, email communications, remote technology, Zoom and other platforms. Client disability is something that you see often in your line of work, telephonic intakes, and conflicts of interests. We're going to cover a lot of ground. Let's start with text communications. I'm a little bit older, from a more seasoned generation, and I don't text as fast as many of you probably watching. My daughter is such an expert on that. So text is not a form of communication that I actually use a lot. I'm the pick up the phone type of guy. But anyways, texting is the most informal form of communication. You all need to understand that, especially the new generation watching. Um, these days, people actually break with boyfriends and girlfriends and significant others through text. That blows my mind, but it is a different generation. But understand that texting is not the most preferred method, especially to communicate in business. If the message is important, deliver it in person by telephone or via email, okay, the more traditional ways. Understand that. Texts are best left for general messages such as I'll be arriving at mediation in less than 5 minutes, or our conference call will start at 2. More of these informal scheduling type of things. I would not, for example, text a client and say, I'm terminating the representation, or I just lost your motion, the judge didn't understand. Uh, not not the best form of communication for those kind of messages. Be sure to have permission to text a person. I don't give clients permission to text me, although sometimes I have to return a call while I'm in my car or somewhere else, and they obtain my cell phone. I do not encourage texting. I don't think it's a professional way. I don't think that availability to a client at any time, it is good for me professionally and personally. So again, make sure that if you select text for these informal communications of general messaging, that the other side is okay with that. Because just because the person provided you with a cell phone does not mean that you have permission to text them, especially on legal matters. Some technology considerations of texting. Texts are not temporary. Text, they can be saved on the cell phone, or they can, somebody can take a screenshot. So don't think that you can get nasty or spicy, towards the recipient of the text, because you're going to get away with it because it's a text. Understand that there's some permanency to a text. Text threads can be altered. Most smartphones allow users to delete and kind of manipulate the thread. So understand that too, especially if you're communicating with a client and there's a back and forth, which I strongly discourage as not the best practice. And then things happen in the future and they show a text that jumps 2 or 3 of your text. And then here we have a complete battle of technology at hand. I've seen that in bar complaints, and it's just not where you want to go. And I always say, why were you texting that? Why didn't you pick up the phone or send an email? Use sound judgment when texting, please. Although texting is an easy and quick form of communication, lawyers should consider those they text and receive text from. Okay, so be very professional, very professional. Don't downplay that type of communication just because it's a text. Communication by a lawyer is a communication by a lawyer, whether you send it through a smoke signal or you send it through a text. It should maintain the levels of ethics and competency and professionalism at all times. Emails. This is an area that we're all familiar with. Emails are not a good substitute for face to face contact and telephone calls for interpersonal communication. So I would always err on having a face to face or a telephonic call with a client when the matter deserves that kind of attention and the client deserves that kind of attention. Do not replace a good call or a good face to face with an email. Email messages may become part of a court record and may be subject to disclosure to third parties. So very important. Some people treat emails as a lesser form of communication. And if there's one thing I want every legal aid attorney watching, and also the support staff watching, to remember is that a communication is a communication. So don't don't create divisions and higher and lessers. Hey, in person, email, text. If you're doing it in your professional capacity, is a communication for the Florida bar. You're not going to find a rule that says this is for emails, this is for letterhead, this is no, it's communication. Compose email messages with the same in the same manner and with the same good judgment that you would employ for any other communication. I have represented attorneys who in their minds thought that a an email was a completely separate type of communication and had a different standard than a letterhead letter. You know, when you send a letter in letterhead, I don't know where that comes from, but I can tell you no. Um, Treat every communication in writing as if it were under your letterhead. Email should not be used for last minute cancellations of meetings or interviews, and never for devastating news. It's common sense. Sometimes we get detached from the tasks at hand. Um, I've had attorneys email me on my way to a depot. Oh, it's not happening, and I don't look at text when I'm driving. I'm one of those, or emails. So I didn't read it. That's so unprofessional. So unprofessional. It happened before the pandemic, and I'm sure it's still happening now these days. If you need to deliver bad news, a phone call or meeting is preferable. That's a client deserves that, okay, and it should be first in mind in your mind when devastating news has to be have to be given in a case. It should be done in a way that it's at the level at the standard of the delivery of the information, and doing it through a text or email probably in most critical corners of a case, it's not the way you want to go. It is best practice when it comes to emails to never leave the subject line blank. And I do get to see a lot of communications from attorneys because that's what I do for a living. I advise, I counsel, and I defend attorneys. And sometimes it's so unprofessional when I see these emails without a subject line being sent to the client or another attorney. Come on, if you're sending a communication, it should have an email communication. It should have a subject line. Use a descriptive subject line that pinpoints exactly what you're mailing about. It's just the right way of communicating, especially on emails. We all receive dozens of emails or hundreds of emails daily. And that is a sign of respect and professionalism when you let the reader know what is included, what is the email about. First of all, it helps the reader prioritize. And second of all, there's no misunderstanding, especially if there are multiple communications on different issues. I actually have a case right now where subject matters were not disclosed in the subject, and an attorney was responding to a different email, and it was a similar case and a complete mess, and it's because of the subject line. The content you could not tell. It could have applied to probably 20 cases that attorney had, but it was sent to this individual, and everything went downhill from there. So very important to be professional. Don't hit reply to an old message and send an email that has nothing to do with the previous one. Huh? How many of you hate that? Let me raise my hand. Please, again, treat email forms of communication very professionally. Use a salutation. Some attorneys have lost the touch of professionalism and class, and just go back to the way of life where you take a second and say, "I hope you're having a good day." I mean, be courteous, be kind, and then you can say whatever after, not whatever, but you get what I'm saying. Make no assumptions about the receiving party's gender. Your email greetings, should be consistent with the respect and formality of any other communication. Be courteous, as I said, and with any other form of communication, especially, like, as I said before, even if it's not a letterhead type of communication, it should be at that level. Do not be rude. Don't make remarks that you would not really make in a letterhead. Um, just be professional, and there's a rule there that tells you a little bit about that. Don't use all caps. Raise your hand if you do not appreciate getting an email that has all caps. I don't know why people do that. Look at the hands. People are awake. Thank you, Florida, for being awake. Yes. What is that all about? No, don't do that. It can be read as shouting and makes your email difficult to read. It sets like the wrong tone. Maybe you're just saying congratulations for your great accomplishments, and you're already a little bit on the annoyed side just because they're all caps. You'll get it. We've all received one of those. Edit your email. Do not ignore the basics of writing, punctuation, and spelling. And watch your tone. I don't know why emails have degenerated to what they're these days, especially some that I see from clients, meaning attorneys that I'm helping. No, no, no. Why can't you write a complete sentence on an email? Again, treat your emails like a communication that deserves reading, that deserves to be cut and pasted into a letterhead, a page. Be professional. Sign your email, include information such as your phone number, position, location, and email address. Maybe that doesn't happen much in legal aid because you're all part of an organization, but I see that a lot. I see a lot of unprofessional communications where the person doesn't even say who they are. You got to look at the email. That's not very professional. Bad habits. Add the email address last. Think about that. This ensures that you don't accidentally send an email before you have finished. How many of you had done that? Guilty as charged. Yes, it happens. You are dealing with 20 things at the same time, blah, 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 and then you send an email before you have finished. It's just not. I'm proofreading it. This is a little tip, and I do that. I do this a lot. I wait, and then when I'm ready, I put the address. It's just a little best practice type of tip. Email should not be used, especially, by the way, if you are sending a bad email, an email that you need to read it a couple times to make sure that, hey, I'm conveying exactly what I want to convey. Yeah, don't put the email address until the end. Email should not be used to resolve conflict, okay, and to say things that were not be said in person. I see this a lot. The attorneys don't want to face the client for whatever reason, and then you have the battle of the emails. Not the best way to handle a difficult client and resolve some conflict, um, either with an attorney, opposing counsel, or with a client. Not recommended. I see the worst side of people because, again, they don't treat emails with the same degree of professionalism, and it goes down the hill. That one email after the other, and then at the end, it's like you're in the dumpster. It is best practice not to leave the sender hanging. I think that 24 to 48 hours to respond is probably something that is in the realm of reasonableness, and generally acceptable. Waiting a week, 2 weeks, probably not. There's no standard, from the floor of the bar. It depends on what you do for a living, and many other variables. But you should always try to achieve that 24, 48, maybe 3 days, but no more than that. It can be perceived as unprofessional. It is also best practice to use reply all only when appropriate. Let me see the hands of people that do not like the reply all on all kinds. There we go. Thank you. Thank you, Florida. Don't do that. It's not funny. It's not cute. Be careful when replying to a message that was sent by a bulletin board or automatic remailer. Please, your reply may be sent to the entire audience. I'm sure that doesn't happen to uh, Florida Legal, but it happens. Let's stop that. As a matter of both courtesy and efficiency, include the original email when you reply. And it happens to me sometimes. I have people that are following up on something, and they don't tell me what the email was, and I send a lot of emails out. I have a lot of clients. I do a lot of consulting across the state. Please, it's just have the decency of letting me know exactly what you're responding to. It avoids confusion and makes the sender search for the original message more work. So please, replying to an angry email. Let's talk about this. Step away. Step away from the computer. An angry email will usually trigger your own anger. The worst of you may come out. Never reply to an email right away. It will only escalate the issue. A side note, I've been married 25 years. This is a way of living for me. Don't fall for it. Step back. Think about it. Identify the facts in the email. Does the writer have a reason to be angry? Did you say or do something that legitimately offended the person? Be objective. Take a look of what exactly triggered that angry email. You may have responsibility in having caused that response. Evaluate what the writer got wrong. Sometimes it's a miscommunication, a misinterpretation. Did the writer misinterpret a letter or get the wrong information? Think about it. Don't just respond. There may be something that is triggering, and if you objectively take a step back, you may be able to identify it and resolve it in a way that is easier for everybody. Begin your reply with positives. That's a good one. It's a good tip. Explain where the writer was right and that you understand why the writer is upset, and then you explain what has been done to fix the problem, or apologize, or clarify. So be positive. You don't have to go down the dumpster. From that point down. No, try to lift the conversation into something that will be productive. Do not get emotional or confrontational. Emails don't show emotions and confrontation very well because it really is in the mind of the reader. You can you're not listening to a voice tone, or you're not listening to somebody that is being sarcastic. You are imagining it because you're not, that sense is not really there. So avoid name calling, placing the blame, and using sarcasm. State your I'm a little bit sarcastic sometimes. State your side of the issue. Be persuasive, and try to work it out. But yeah, don't, emails that are emotional, confrontational, don't end well. That when you put them, next to each other, it doesn't read. They don't read well. It is also best practice to use reply all only when appropriate. Okay, I said that and I'm saying it again because if you reply all with an angry email, woo. So yeah, I put it there again. I'm sorry. As a matter of both courtesy and efficiency, include the original email. I said that, and don't be afraid to give consequences. Actually, if the business relationship cannot continue, say so. Be straightforward, but do not threaten to file a bar complaint. And this is not unique to emails. You should never threaten to file a bar complaint against another attorney. That shouldn't be done. If you're going to do it, you do it. But yeah, stay away from that. And if you need a refresher, of course, criminal prosecution. You can look at 4-3.4 GNH. Okay, stay away from that. Be respectful and civil, and think about how permanent emails are. Okay, so again, it's a communication. It's a communication that can be saved. Save records of your correspondence. Things happen in law firms. Systems are down, this and that. So learn to save those communications that need to be saved. Don't rely on the fact that you expect that email to be there a year from now. It may not be the case. So protect yourself. Okay. Secure client portals are now being used a lot. I don't know how into technology some of our legal aid offices are, but that's a technology that is out there now, and is being used by a lot of law firms. They are safe, secure, so it's easy to put in. So this is a consideration. Sorry, I didn't read the heading. Technology considerations. So that is a new thing that is going on, and it's really great. Remember that behind your your email or your PDFs, there's metadata behind it. Okay, and it's very important that unwanted info is not taken out of. This is not something that we see as a practitioner, but there are components of technology that we use that take care of all of these things for us. Malicious software, secure encrypted messages are being used a lot now as part of the communications. So again, I don't know how advanced are some of your systems, but very important to be at the forefront. And it's very expensive. I understand that, especially for our government side. Remote technology by the numbers. Just to put in perspective how we have really taken leaps forward in technology in the last 10, 11 months. As of November 2020, 2.5 million cases were disposed of using remote technology in Florida. Unbelievable. 73% of respondents to a Florida bar survey reported video conferencing with clients. I think that's here to stay. 67% of respondents cited Zoom as their primary platform for court-related events. 46% reported using video conferencing for mediation. So, yeah, this is here and it's here to stay. I am sure that you, as legal aid attorneys and support staff, are embracing this. It's cheap technology, really, and it's here to stay. So we got to get better and better at it. Some of the challenges, according to the survey, um, include some of these complaints that when they have deponents, they are not receiving. They feel that They can control the room, and it's impossible to verify somebody is actually prepping or assisting. There should be a second camera showing the entire room. An attorney said the doorbell function in Zoom to announce coming and out of rooms. Like, apparently, some people stay on and they take a break, and there they are talking to their clients. So all these are practical things that are happening out there. So we all have to learn, this process. But the Florida Bar Technology Committee is actually working on some recommendations, and looking at all the good and bad that is coming out of these virtual lawyering that we're doing now. Best practices. So let me give you some advice, and I use some of this for my own. I'm a civil practitioner, and I do take a lot of depots. In advance of the day of the depot, the court reporter should be asked to provide the necessary credentials and login information to all participants. I don't know if you have experienced this, but I've had attorneys that they're ready to go, and then they didn't send the login info on time, and now they're sending it last minute while I'm waiting. This is not business as usual. Some attorneys think that we're still on the old-fashioned way, that you grab that file, that accordion file, you drive, you show up at the depot place, open the file, get your yellow pad, and you start the depot. No, virtual depots are not like that. They require preparation. You need to send that link beforehand. Some people may be in a place where they don't have, the internet or their email available, and they're using somebody else's computer, and it delays the depot. These are things that need to be done beforehand, not the day of the depot. Witnesses receiving links. That is not professional. If a video deposition, witness should be instructed ahead of time to be positioned in front of a suitable background. Some people have, backgrounds that are not professional. Your witnesses, if you are producing them, should know beforehand what is expected. This is not just show up and turn on your computer. There is some preparation that was not necessary the old-fashioned way, in-person way. Counsel should note on the record that the deposition is being conducted under Florida Supreme Court Administrative Order AOSC 2023, which is the emergency, and some things are relaxed because of the pandemic. Order authorizes persons qualified to administer oaths in Florida to swear a witness remotely by audio video communication technology from a location in Florida. So read that order if you haven't read it. Witness must present identification. That's another delay. I've been to depots where, oh, I need an ID. Yes. Oh, then they get up. They have to go to another room. Or worse, they don't have an ID on. They don't have it, so everything has to be rescheduled. That witness, that the position, the person being deposed, should be ready to do this. Whoop, raise their hand and put that ID in front of the camera, and let's get the work done. So if it's your witness or if your client and that doesn't happen, you failed everybody. Okay, you need to be ready to go. It requires preparation. Virtual depots require preparation. If notary of or witness is located outside Florida, the consent of the witness to be put under oath with audio video communication should be obtained, along with the stipulation of counsel to that process. Preserve the record, okay? Preserve the record. We're under an emergency order that allows these things to happen. Yep, not an appropriate background. Some people like to share a little bit about themselves with their backgrounds. Legal matters are not the place for you to let people know that you like cats, or that like The Office, etc. Not professional. I prefer to see a door or something else behind than to see your favorite magazine or whatever on Zoom for 3 hours. It's just not professional. A particular concern in a remote deposition is the coaching of witnesses by someone in the room. And these are some of the things that I personally follow. First, the witness should be asked to state under oath whether there are other persons present and to identify such persons. The exclusion of non-parties and non-essential persons should be sought under Florida Statute 90.616, exclusion of witnesses, and consider asking the witness to span the entire room with a camera and position body so that the camera shows the door to the room. I do that. I love seeing the door. I want to know who is in and who is out, and it gives me control of the depot. Yeah, I don't want to see the window. I want to see the door to the room. Witness must appear on camera, no blank screens, in advance of the day of the depot. Again, preparation. The court reporter should be asked to provide the necessary credentials and login information to all participants. And of course, you should tell the witness, if it's your client, to make sure that the background is professional. And refrain from displaying exhibits on the screen until already marked. And during breaks, please switch to the mute function. Don't start talking to other people while that microphone is not on mute. It happens. It happens. That is me sometimes. In my Zoom meeting, no. I always dress up to work, so I don't work from home. So that would never be me, but it may be some of you. The problem with this, as some of you have seen in the news, is that some people don't wear pants and they forget that they're not wearing pants, and they look good from the maybe the shoulders up or the second button up, and then somebody rings the bell or a kid drops something in the kitchen, and the reaction is to get up, and guess what? It's happened. My advice on that is dress for success. Even if you're at home, you should have pants on. You should look professional, and you know, that's the way to do it, because you may have a fire that starts in that room, and you got to get up, and it's not professional. Okay, so that's all I have to say about that. Telephonic intakes. Consider these tips. Okay, keep it simple. Keep it simple at first. It's very important that you get to the bottom of everything, but in a very astute way. Don't overdo the first intake. Clients get overwhelmed. Don't bombard the client. Just ask the questions you need to ask in this first meeting. They're still reading you. You're still reading the client. So very important. And those intake forms, you guys are experts on this. I mean, really, legal aid offices across the state. You have so many clients, and your staff does such a good work. That has been my experience in trying to weave through the issues to make sure it is ascertained what exactly is going on and who that person needs to see. Um, Contact info, the root of the issue, what the client decided, why they decided to call you. And if you decide to set a first meeting, gather any additional information for anyone who the client authorizes to give updates on the matter. This is very important. And you probably see a lot of this because you do get a lot of third parties sometimes involved in some of your cases. And it is very important that you cover yourself, that you protect yourself with the proper authorizations to discuss matters with the different third parties. And all of this will help you, go to the heart, go to the right people with the right info to help that client. Time is money, and for you all watching, your time it is your life really, because it's you don't get paid a lot. You should. So it's really your life, the time you do this, because you have a heart that takes you through that route. You more than anybody else should avoid wasting time by setting time limits for initial intakes, asking pointed questions. That's not good. Using an intake form that covers all the bases and follow up from your staff to fill in any blanks. Bad. Just try to do it right the first time. As a private attorney, when somebody else does an intake that is not complete and it's not professional, I don't like that. It makes me very angry. Always remember that, and then I'll send one of those emails that I said people shouldn't send out. Always remember that this phone call is important to your prospective client. Use courtesy, respect, be engaged. Give that client the best of you during that time. Okay, very important. And again, you are all under great constraints because of the amount of clients that you have, and you don't get to choose them. Sometimes they just come. So it's very important that you center yourself every day and try to give 100%, especially in those initial consultations. Don't underestimate the power of their perception. And if somebody perceives that you don't care or that you're disrespectful, that you don't want to be there, it's going to damage not only the reputation, your reputation, but also of legal aid. So yeah, we gotta find the strength. And of course, you all have developed some reusable system of intakes and all of that, and you have it down. It doesn't take a long time to get in the groove of practicing at legal aid because there is a way. There's a formula to the madness. There is. I know that for a fact. An intake process can always be improved. You're all participants of the lawyering at legal aid, and your leadership should always be open to new ideas and ways of doing things better. Don't be afraid of giving your input. I personally know associate attorneys that are smarter than some partners and managers in law firms. I'm not talking about my law firm, but through my interaction with law firms across the state, I have met many bright associates that are starting that are smarter than their bosses, and it happens. So hey, welcome input to make your law firm, the legal aid law firm, better and more efficient. Okay, client's disability. You have some challenges here. Probably you see it more than a regular attorney in the economy out there, and that's why I included it. And some of you probably haven't seen this rule in a while, so let's look at it together. 4-1.14, client under a disability. A, maintenance of a normal relationship. You have to work hard with clients that have disability, but understand that whether your connection is because of issues with minority or mental disability or impairment, you shall. The rule says shall, as far as reasonably possible, to maintain a normal client-lawyer relationship with a client. That's the rule. You're not to ignore calls. You're not to, I'm going to call him once a year. No. The rule requires that you treat it as normal as possible, this individual that has some challenge. B, appointment of a guardian. If the time comes where you really cannot maintain a normal client relationship, then you may have to seek for a guardian. And that's what the rule says right here. There's a comment to the rule, and let's read it together. The normal client-lawyer relationship is based on the assumption that the client, when properly advised and assisted, is capable of making decisions. That's what lawyering and the attorney-client relationship is all about. When the client is a minor or suffers from a mental disorder or disability, maintaining that normal, ordinary client relationship may be a little bit challenging. Nevertheless, a client lacking legal competence often has the ability to understand, deliberate, and reach conclusions about matters. So you can't interpose one thing with the other. one thing could be true and the other could be true too. And this comes from the comment of the rule. For example, children as young as 5 or 6, and certainly those of 10 or 12, are regarded as having opinions that are entitled to weigh in legal proceedings concerning their custody. And so it is recognized that some people of advanced age can be quite capable of handling routine financial matters while needing special legal protection concerning major transactions. So it's all a continuum of things that you need to evaluate. Some Several things could be true at the same time. I do get calls now and then of clients of attorneys facing issues like this, and they do a default on everything. So no, and that's not what the rule says. You need to weigh in all these things because you could one thing could be true and another could be true at the same time. So very important to look at the circumstances. However, if you find that the client has suffers some sort of disability, and he or she has no guardian or legal representative, you may be the de facto guardian for purposes of doing what is in the best interest. At the end of the day, your loyalty lies with that client because that is the essence of the client attorney client relationship, loyalty. And that's what the comment to the rule says. And the evaluation of these considerations is a matter of professional judgment of the lawyer. Okay? It's your job to weigh, to balance these things out. Okay? And if there's a guardian that has been appointed, and that guardian you believe is not doing the best on the ward's interest, then you have a duty to correct that. Okay? Even though you're not the guardian, you have a duty as the attorney. And that comes from Rule 4-1.2D. Disclosure of client's condition, that sometimes is something that you got to deal with. And the general terms of the comment say that if there's no guardian and you are the person holding the hot potato on how we're going to approach the case and the client, and there may be a necessity of disclosing the disability of the client that could affect the client's interest, you need to seek guidance from an appropriate from the treatment side. Okay, you are not here at the end of the day to evaluate that. You're not a clinician. So the rule actually says, hey, if the point comes when you have to make a disclosure because you got to do A, B, or C on the case, and you're holding that hot potato, it says go and consult. Okay, get assistance, get professional assistance. Don't assume things. Okay, so this is a very important rule, and keep it in mind because some of you, because of the areas that you do, you come across some of these challenges, and it's important that you know exactly what is expected of you. All these sources that I quoted today in the presentation come from all this material. Okay, I did a lot of reading to put this together for all of you and to make it valuable. I hope that you all got something out of it. Actually, Chrissy, I have the CLE info here since they have completed. No, we're at the end. So it's here if you want to write it down. We have completed our presentation piece. I'm ready for some questions. I'm actually excited about the questions.
Fantastic. Thank you so much. I really appreciate you hitting all the relevant points for legal aid with humor and in such a clear way. I learned a lot. I cringed a lot. I don't know about everybody else. I was like, oh my gosh, I hope I didn't send any inappropriate emails to him while planning this webinar.
You were the utmost professional.
But I appreciate the emphasis on going back to the old-fashioned way sometimes, like writing letters or making phone calls. It is scary sometimes. I know if I have bad news about a case, I dread making that call, but usually it's not a big deal. You just gotta do it. And
gotta do it. Christy, let me say something. I taught a class to a law firm that has several locations in Florida yesterday, and a paralegal asked me, what is the best way of dealing with a client that is threatening, bar complaints or whatever? I'm like, why are you asking that? That's not your job. Your job is not to deal with a client that is in crisis. That's the attorney's job. So I was very clear. I told her, listen, this is a matter that needs to be contained by the attorney. That is not a task of a paralegal to diffuse a potential a crisis with a client. So I'm glad that you're saying that because that applies to legal aid. You guys have a lot of clients, and when I call it that a crisis. When a client is calling and hates everything about you and everything about your staff and everything about everything that you represent in the world, that's a crisis, and it requires the attorney to jump on it sooner rather than later. Those things do not marinate well. Okay, so keep that in mind. Don't dump it on your staff. That is not right, and actually, it technically is a violation of the rules because the rules of communication require attorney-client contact on very important pieces of a case. And I think that the client saying those things about you, it's one of those pieces that requires some attention. So
Definitely. Well, we've got lots of compliments in the chat box. Everyone really enjoyed the presentation and is thankful for your time. And I do see a couple questions here in the Q&A box. The first one is, what about if the person who is calling to get advice is a friend of a person who is showing early signs of dementia or Alzheimer's? Do we stop the call immediately or give some guidance to the caller about what is needed?
very interesting. I don't know if some of you have a policy on that. I can assume that it happens a lot because a lot of people call legal aid for the benefit of somebody else. I don't see anything wrong asking because you don't know the client, um, and you are just giving some general advice. I would assume when they're calling with some specific question, you can say, well, generally this issue, I'm pretty sure you're not giving. Oh yeah, you got to do A and B, and legal advice should not happen. Case by case specific over the phone with a third party. So you should ask cursory questions to point the family member or third party uh, on the right direction, or encourage them to come or set an appointment, because at the end of the day the advice is really going to be provided to the client, and that is not the client. So you should keep it general, and that would be my advice. I screen calls all the time from attorneys that know that I do this business of ethics, and I'm very careful. I do that a lot, and there's nobody to cover the call for me. It's me. I'm the ethics attorney, nobody else. So I handle them like that. I'm like, okay, what is it, general? Yeah, because my husband, I'm the administrator of the law firm. Okay. So your husband or your wife is the attorney? Yeah. Okay. So, and I kind of, I'm very careful. I don't give advice over the phone to third parties, and you shouldn't either.
All right, thank you. Second question is, can you comment on the best way to handle folks with diminished capacity that are not clients yet, but cannot afford to wait for guardianship due to the nature of the legal issue?
Yeah. So they're not a client yet. Is that the question? I'm trying to see
Right,
where we
right.
are.
I think they're thinking about it from like a legal helpline perspective where they're screening a call, but they may not have been assigned to an attorney yet.
And the question is how specific you get. Can you repeat?
How do you help them if they have diminished capacity but cannot afford to wait for guardianship due to
If
the
the client that is calling has diminished capacity,
right?
yeah, that you cannot assess diminished capacity over the phone. I would feel very uncomfortable making a determination with someone that you have spoken to on the phone for 10 minutes. If there's any doubt in your mind that there may be some sort of challenge with that individual on the other side, you should set an appointment or do Zoom, whatever you need to do to have what visual and be able to assess all senses. Phone diagnosis, probably not good at all. I would not engage in that. There are people that you need to meet in person or through Zoom now these days to be able to assess, what kind of condition, but not over the phone. At least I'm not capable of doing that. I don't have that training.
Great
Although
answer.
I must confess that some attorneys that call me, I do feel that I need to go into some of that. I do acknowledge that because
Right. A special challenge, of course, during COVID, but I feel the same way. I meet with my veteran clients. We're going to be together for years arguing with the VA. So
yes, take the
definitely,
time. It takes more time. It is time consuming, especially if you're doing that telephonic thing. But there's things that you can replace. And if telephonic call to assess ABC, I mean, unless you're a clinician, I don't know how you do it.
right. Oh, let's see. So the next question is about some of our clients need some hand holding. That's the understatement of the
Oh
year.
yeah, do you think that's unique to legal aid? Have you ever
I
represented
don't
an
think
attorney who knows it all? No.
we are all special in our own ways. That's what I always say. Do you have any recommendations for the pro bono attorneys on how to handle these clients? So maybe people who are coming from transactional law and they're not necessarily used to working with clients.
Yeah. My advice, and I use it a lot, okay? So I actually practice this advice. When you determine that you have that client, okay, that needs hand holding, what I do is I set up the next meeting. I always leave them with that security, and it works so well. I had one of those last week, and I already know what I got into. Is actually an applicant to the FBBE, and I already read the individual. I know that this is going to be a challenge. It's not. It's going to a lot of hand holding. So what did I do when I ended the conference to neutralize it and to satisfy the expectations? So are you starting now to work on it? The next meeting, I still have a paper schedule. I feel terrible, but I don't do computer. I open a calendar and I actually write stuff and I carry it all over the place because I'm always all over the place, here, there, at hearings, and I'm able to quickly. I don't trust technology, so I open it and I know exactly what my schedule is. I opened my book and I said, let's reconnect in 2 weeks, and I plan on doing A, B, and C. That neutralizes, and it also gives them something to look forward to instead of marinating. I'm using the word marinating. I like cooking. In when am I going to hear from Juan? It's all set. It takes a level of stress away, and it helps you manage the client better. So always give that follow up. Yeah, in 2 weeks, or give me 6 weeks, or it helps. That's how I manage my problematic clients, and it works 99.9 because they always know that they are expecting to hear back from you at some point, and it brings peace, and it prevents calls and emails and excitement, etc.
I like the marinating term too. I
Yeah,
use that term when
a
I'm
lot of
marinating
marinating,
on a
a lot
case.
of marinating.
That's a great tip, and I appreciate that I'm not the last one in the world with a paper calendar. Yes, I am the same way. Electronic is just not the same. So we have another question. Is it sufficient to receive only oral permission to discuss a client's case with a family member?
Excellent question. Is it sufficient? I say no. I think that at a minimum, you should follow up with a communication stating that, as discussed today, your brother gave me permission to discuss this case. You should always cover your back. You should always protect yourself. So even if we was given oral, you should what? Follow up to put it in writing. Always have that piece of paper. Oh, no, I responded to your uncle saying, as the client said, I can speak to you, the uncle. Always document everything. So maybe at that minute, you had to do it that way. That's fine. But follow up, and don't wait 7 months to do that. Go get into that habit of doing these things to protect yourself. Closing time is the best thing to do. I do it all the time. I give a lot of advice on the phone because I may be driving and I'm consulting. I'm on retainer by many attorneys, many law firms, and partner so and so calls me in the middle of a depot. Hey, they're doing this. Is that unethical? What? How should I handle that? And I'm giving advice. I park to the side, and there I am running through ethics, and analyzing for 20 minutes. And what if the partner said that I said to do B? So what I do is, hopefully as soon as I can, when I get back to the office or at home, I open my computer and I quickly, as I told you today, always cover your back. Always. So I do it all the time. It takes time. It's annoying. I wanted to go to my daughter's activity, but now I'm typing something for 10 minutes. It's worth every minute because I sleep at night so well because I cover my back all the time.
That's great advice to not only cover yourself, but I find that it's helpful for our clients. We're giving them a lot of information all at once. They're stressed out about 10 different things. I don't know about you all, but I don't remember important things like after I go to the doctor's office unless I have my little notepad with me. So it just helps them to remember what you told them so that they don't have to ask you over and over again.
Absolutely. That's the best practice.
Old-fashioned letters, nothing like it.
Yeah.
One last question. Can you talk about the best practice for communicating with clients via phone or Zoom when they have family members, including children nearby?
Yeah, great question. Last week, I had an applicant to the bar that had a meeting with me, and the kids were roaming around. I rescheduled. I don't think that that is professional. I don't think. Listen, if that doesn't happen in your office, I would not allow that to happen in my office. I need the attention. I'm talking about very important things. I would not do it in my office. I'm not going to do it, in your house through Zoom, because your attention is not on me. I'm doing you a disservice very often because of that side of my practice, the FBBE cases, the applicants to the bar that are being investigated for character and fitness. Many of them are in law school, so they have very tight schedules. Some of them have jobs, so they actually work. So what do? I set them for my meeting at 7 p.m. I eat into some of my private time, but let me tell you, I prefer to do that Zoom at 7:30 when the other parent or somebody else can be helping with the kids, and do it at 7:30, then do it at 2:30 from this office and not get the quality of the interaction that I need with my client. So there are other ways of doing this, and I have defaulted to that, and I've done it a lot. I never um, really used to do that, but because of Zoom now, you can, without having to be in the office at 8 p.m., you can accommodate people with needs like that. And I've been doing it pretty often, especially on the FBBE side, and I'm fine with that because I don't want to have somebody who is a clerk for a law firm hidden in a bathroom talking to me at 12:30. It's just not right. So yeah, my hours have expanded now a little bit more, but some clients require that, and I'll do it.
Thank you so much for all the great advice. We got lots of compliments in the chat, and I will send out the PowerPoint as long as our speaker is okay with sharing it with
Absolutely.
everyone.
Yes. I
Along
send it
with
to you.
the
Yes.
Perfect, thank you. Along with the recording tomorrow. And just in case anyone is on the phone and can't see the the CLE number is 2009-733, N is in Nancy. Thank you so much for doing this. I really appreciate this. It was a really lively ethics presentation with so much
Excellent.
good info packed in
Thank
there.
you for the invite, and again, thanks for your service. You all serve and serve the people that need it the most. So you should all be proud and sleep at night satisfied that you're making a difference, because you are. You guys are warriors. Thank you. Be safe.
Thank you so much. Take care, everybody.
Bye
Bye-bye.
bye.